Good morning. First of all, I'd like to thank the organizer for inviting me to this very important conference and very timely one. And I would like to take from the two observations by Professor Nguyen about the implication of the UNCLOS with regard to international law and the South China Sea, but from a slightly different perspective. By the way, I'm a lawyer, and as a lawyer, I'm rather optimistic about the future and the value of law in international relations. And my presentation will take from the international law perspective, particularly the role of UNCLOS in the establishing in preserving the legal order of the ocean. And the first thing is that when you look at UNCLOS and look at the role of UNCLOS, we have to recognize that the way UNCLOS manage dispute is we often call the zonal approach. What is a zonal approach is that the oceans and the seas are divided into different maritime zones, the territorial seas, exclusive economic zone, continental shelf, the high seas. And with different maritime zones, we have different regimes. And states have a different obligation and rights in these different maritime zones. And the second thing is that we look at UNCLOS as a constitution for the ocean. We have a Professor Shirley Scott here who writes about how you can see a lot of the sea convention as a constitution. It's not a constitution in the domestic sense, but it's a constitution in the sense that it establishes rights and obligations on a level playing field for all the states. And that brings me to the third issue from the law of the sea perspective, that the validity of the UNCLOS. We often say that the arbitral UNCLOS between the Philippines and China is only final and binding, but only between the Philippines and China. But I don't think so. I think that in establishing or determining the extent of China's rights, the extent of China's and the limits of China's entitlement in the South China Sea, the UNCLOS has more than that. It has a erga omnes effect. And let me give you an example. For example, I have a dispute with the Defense Force Academy here about the sovereignty over this podium. And the court said that, now you don't have a sovereignty over this podium. I cannot tell you that now it's not binding between you and me, only between me and the academy. And I still can claim the sovereignty over this podium. So I think in doing so, the judgment is binding on me, and binding on me about what I have and what I do not have. Then it's also have a binding effect toward all other states, towards all members, audience in this room, that I do not have a sovereignty over this podium. And so with that, I think that the UNCLOS have a very far-reaching effect in terms of determining the maritime entitlement in the South China Sea. And you have a look at this map several times today, this morning in the, and I thank Professor Nguyen and his student for this very wonderful map and useful for the presentation. And only a slight note that because of the copyright issue, I dare not erase the 9-dash line on this map. But the situation now here is now we do not have any red dash line on this map. You only have the blue, the gray, and the yellow zones on this map, and forget about the red dash line. And you can see from this one, and as Professor Sconfin already showed you, that there's now the 200 exclusive economic zone of all the coastal states in the South China Sea. The coastal states are also entitled to claim extended continental shelf beyond 200 nautical miles. And there may be high sea in the South China Sea. There may be also the area in the South China Sea, in the center. The area is a maritime zone, the seabed, which beyond the continental shelf of the state. And that is subject to a common heritage of mankind regime that is not belong to anyone but shared by the international community together. And whether there could be any area subject to the common heritage of mankind depends on the further submissions of the coastal state in the South China Sea. And you can see that the yellow part on the South China Sea, actually the extended contour shell submissions by Vietnam and Malaysia. And now you can see that it's up to China and the Philippines or maybe Vietnam to make further extended contour shell submission. Of course, if China make any extended contour shell submission, maybe you have to get rid of his historic rights, as declared in his government statement after the award. But it's up to China to do so under UNCLOS. So I think that with the new, we often call the new legal landscape after the award, the legal landscape where you have a fairly clearly defined maritime zones which belong to the coastal state and which is not, which cannot be claimed exclusively to any state, that is high sea in the South China Sea. You can apply different provisions, obligation of the coastal state in the South China Sea within this new framework of jurisdictional zones in the South China Sea. And I can see that there are several provisions or several activities that have been facilitated by the new legal landscape that the award created. That is, first, we have often talk about the declaration on the conduct of parties in the South China Sea. But so far, you have, after 10 or 11 years, you have guidelines on the implementation of the code of conduct. But so far, has no activity at sea have been implemented. And I think that one of the problems is that you do not have the precise geographic scope for those activities at sea. And I think with the new legal landscape created by the award, then you can see how you can apply different the paragraph in the declaration on the conduct of parties in the South China Sea. And I'm talking about paragraph 6, which provide for cooperation between ASEAN and China on less sensitive areas. And it provides for some activities, and I think that to carry out those activities, you need to know the location of those activities within the framework of the Law of the Sea Convention. You need to know the relative location of those activities in the jurisdictional zones of the coastal in the South China Sea, and those are the maritime environmental protection and marine scientific research. And under the Law of the Sea Convention, the coastal state will have a sovereign rights to regulate those activities in their exclusive economic zone. And with the new legal landscape created by the award, you can know where you can conduct those activities and who you can get permit for those activities. And it will not create any ambiguity for state to claim one day after that actually I do not, I carry out this activity without your permission, but because I have a sovereign rights over those activities. So I think that the clearer legal landscape may have facilitated those activities. And the second activities, I think, is you can see as on the map by Professor Schonfin that there's high sea in the South China Sea. And that triggered another provision in the UNCLOS. That is Article 36.2, which talks about the transboundary fish stock between the exclusive economic zone of one state and the high sea. And Article 36.3, paragraph 2 says that where the same stock or stocks of associated species occur both within the exclusive economic zone and in an area beyond and adjacent to the zone, the coastal state and the state fishing for such stocks in the adjacent area shall seek to agree upon the measure necessary for the conservation of this stock in the adjacent area. And that's exactly the point that Professor Schonfin raised in the later part of his presentation about the need to prevent incident at sea, about the need to prevent those incidents relating to fisheries. And I think this is one of very, very useful provisions for the states in the region to cooperate, to preserve the fisheries, to preserve fish, for the fishing stock that traverse between the exclusive economic zone and the high sea in the South China Sea. And another activities is the encouragement by one provision in UNCLOS for further cooperation between coastal states in a enclosed or semi-enclosed sea. And that is provision 1, 2, 3. And the language of that provision is more of an encouragement rather than an obligation. But I think that when you look at the provision, it talks about the management and conservation of the living resource in the air and the sea, and the implementation of the rights and duty of state with regard to the protection of and preservation of the environment, and also about the conduct of marine scientific research. All these activities also predicate on a precise legal framework, precise maritime zones where those activities occur. And I think that with the fairly clear defined maritime zones by the award, you can now be more confident to carry out that kind of cooperation. Because in the past, we do not know who will have a sovereign rights to regulate those activities. And I think that in the past, you will be not have enough confidence and trust in each other in carrying out these activities, just because of we do not know where your maritime zone is and where their maritime zone is. And I think that with that is that paragraph also, the implementation of this provision is also facilitated by the award with the new legal landscape. And the final provision is the final activity that I think might be facilitated by the award is the consultation, the ongoing consultation on the so-called COC, the Code of Conduct in the South China Sea. And if you can recall that in the past, we have a lot of difficulties with the COC, the previous COC. The previous COC was, the negotiation of the previous Code of Conduct was commenced in 1999. But because of the disagreement over the location or the scope, geographical scope of the Code of Conduct, because of the disagreement over certain other issue, but I think that the geographic scope for the application of the code is a very major issue in the negotiation, that you cannot agree upon the Code of Conduct. And that instrument was downgraded to a declaration on the conduct of parties in 2002. And now we have another round of negotiation or another Code of Conduct. And I think that the new legal framework, where you know where the maritime zones of each coastal state is and where the high sea are, and also you know what are the activities you need to regulate. What will be the disputed waters in the South China Sea? So you can, I think that you can have a more to talk in the negotiation of the new Code of Conduct. And I think that will be facilitated too. The consultation on the Code of Conduct will be facilitated too. And it's very interesting to note that after the award, and one of the, I think Chris, you mentioned about the catalyzing effect of the award is that China has now agreed that we should have an outline of the Code of Conduct by the mid of 2017. And I think that I'm optimistic, cautiously, about the effect of the award on the consultation of the Code of Conduct. But that's some of the issue I think that the award has facilitated with regard to the activities of coastal state in the South China Sea. But I think that the accord also left a lot of things for the state to do. And I mentioned that's another 4 issues that I think that it's imperative for China and ASEAN countries to discuss. The first thing is that and because of the submission of the Philippines, are limited to only a number of features in the SPAR list. So it is now for China and also claimant states of ASEAN to clarify the rest of the SPAR list. The threshold is that there will be no island, the fully entitled island, which are capable of generating exclusive economic zone and continental shelf. But you still have to determine which features are rocks and which are low tide elevation, and which low tide elevation are located within 12 nautical mile territorial sea or rocks, and they can be used as a base points for those rocks. And I think that there are a lot of things to need to be done between the ASEAN claimant state and China. The second issue is that the status of the parcels. The award is only concerns the status of the SPAR list. And this is another point that Professor Schoenfeld talked about, the normative effect of the award. The reasoning of the tribunal, the way the tribunal interprets and applies Article 121 to the SPAR list may be very useful for China and Vietnam in their re-examination of the status of the parcels. And it's up to China and Vietnam to determine the status of the parcels, of course, must be in light of the award. And the third issue is that in the award, the tribunal accepts that the territorial sea of the Scarborough Shoal is the traditional fishing grounds of the Philippines, China, and also Vietnam, and maybe other states. But there are 2 issues here. The first one, the tribunal declined to specify the threshold of the fishing method of traditional fishing activities in the Scarborough Shoal. And it said that it must be artisanal fishing activities. But I think that the Philippines and China and also Vietnam and maybe other states need to determine what will be the fishing activity, what fishing activity can be considered as traditional fishing activities in the Scarborough Shoal. And also the second one, who can fish in these traditional fishing grounds? The tribunal say that, and it's very interesting that the Scarborough Shoal is the traditional fishing ground for fishermen of many nationalities, including, that means the list is not exhaustive, and it includes China, including Taiwan, the Philippines, Vietnam. So it's open for at least these 3 states to discuss who can join the fray, who can join this, the management of these fishing, traditional fishing grounds. And the final point is that you can see that the Scarborough Shoal is near the Philippines over the eastern part of the South China Sea. And Vietnamese fishermen are recognized as traditional fishing there. So I think that it's not far-fetched to argue that there can be traditional fishing grounds in the SPAR list and in Paracel Islands. And if there are traditional fishing grounds in the territorial sea of the Paracel and the Spratly Islands, who will be able to fish there? And there's also the issue of management of those traditional fishing grounds. But I think that is also another area for at least Vietnam, China, and also other claimant states in the Spratly to discuss, as well as to preserve. And I think that is also the way to prevent future incidents relating to fisheries, as Professor Schoenfeld just mentioned. So my conclusion is that the tribunal has helped the parties a lot in their future activities in the South China Sea, but also it also leave a lot of things for the state in the region to do with what. And with that, I thank you for your attention.